Hello, my dear students. Today, we'll study Industrial Disputes Act 1947, and under that head, we'll talk about the powers of the appropriate government. Today, we'll talk about the power to exempt given to the appropriate government under Section 9B and power to reference of disputes to boards and tribunals given under Section 10. This is video lecture number 27. My dear students, powers of appropriate government only reprieve for employers is Section 9B under the Industrial Disputes Act, which gives power to government to exempt the provisions of Section 9A. In exceptional circumstances, where the application of 9A may cause serious repercussions on the industry concerned and if the public interest so requires. So this is the power of exemption given to the appropriate government under this Section 9B. Section 9B, the power of government to exempt where the appropriate government is of opinion that the application of the provision of Section 9A to any class of workmen employed in any industrial establishment affect the employers in relation thereto so prejudicially that such application may cause serious repercussions on the industry concerned and that public interest so requires the appropriate government may, by notification in the official gazette, direct that the provisions of the said section shall not apply or shall apply subject to such conditions as may be specified in the notification to that class of industrial establishment or to that class of workmen employed in any industrial establishment. So, my dear students, this is the power given to the government to exempt where the appropriate government is of the opinion that the application of the provisions of Section 9A to any class of industrial establishments or to any class of workmen employed in any industrial establishment affect the employers in relation thereto so prejudicially that such application may cause serious repercussions on the industry concerned and that public interest so requires, the appropriate government, by notification in the official gazette, direct the provisions of the said section shall not apply or shall apply subject to such conditions as may be specified in the notification to that class of industrial establishments or to that class of workmen employed in any industrial establishment. So this is the power given under Section 9B to the appropriate government. Now, my dear students, we'll talk about the powers of appropriate government given under Section 10 under ID Act 1947. So under Section 10 of the ID Act, the appropriate government enjoys discretionary powers to refer an industrial dispute to the court or tribunal. The law prescribes 5 major provisions for the reference to a dispute. Usually the matters under scheduled second falls under the under schedule third, I beg your pardon, falls under the jurisdiction of the tribunal. So my dear students, the appropriate government under section 10 enjoys this discretionary power and may refer an industrial dispute to the court or to the tribunal, and the law prescribes five major provisions for reference to a dispute. Usually the matters under schedule 3rd falls under the jurisdiction of the tribunal. Section 10 refers to the dispute or the power is for the reference of the disputes to the boards, courts, or the tribunals. So when these matters may be referred by this appropriate government to the boards, courts, or the tribunals, where the appropriate government is of opinion that any industrial dispute exists or is apprehended, it may at any time by order in writing. So my dear students, whenever under section 10.1, where the appropriate government is of the opinion that any industrial dispute exists or is apprehended, it may at any time by order in writing, means government in order in writing, refer A, clause A, refer the dispute to a board for promoting a settlement thereof, or refer any matter appearing to be connected with or relevant to the dispute to a court for inquiry. And this is clause B. And then clause C, refer the dispute or any matter appearing to be connected with or relevant to the dispute if it relates to any matter specified in the second schedule to a labor court or for adjudication. So clause C says that refer the appropriate government, refer the dispute for any matter appearing to be connected with or relevant to the dispute if it relates to any matter specified in the second schedule to the labor court for adjudication. Then under section 10, subsection, I beg your pardon, clause D, the refer the dispute or any matter appearing to be connected with or relevant to the dispute, whether it relates to any matter specified in the second schedule or the third schedule, to a tribunal or for adjudication, provided that where the dispute relates to any matter specified in the third schedule and is not likely to affect more than 100 workmen, the appropriate government may, if it so thinks fit, make the reference to a labor code under clause C. And provided further that where the dispute relates to a public utility service and a notice under section 22 has been given, the appropriate government shall, unless it considers that the notice has been frivolously or vexatiously given, or that it would be inexpedient so to do, make a reference under this subsection, notwithstanding that any other proceedings under this act in respect of the dispute may have commenced. So my dear students, provided also that where the dispute in relation to which the central government is the appropriate government, it shall be competent for that government to refer the dispute to a labor court or an industrial tribunal, as the case may be constituted by the state government. And where the central government is of the opinion that any industrial dispute exists or is apprehended and the dispute involves any question of national importance or is of such a nature that industrial establishment situated in more than one state are likely to be interested in or affected by such dispute, and that the dispute should be adjudicated by a national tribunal. Then The central government may, whether or not it is the appropriate government in relation to that dispute at any time by order in writing, refer the dispute or any matter appearing to be connected with or relevant to the dispute, whether it relates to any matter specified in the second schedule or the third schedule, to a national tribunal for adjudication. And under section 10, subsection 2, where the parties to an industrial dispute apply in the prescribed manner, whether jointly or separately, for a reference of the dispute to a board or a labor court or a tribunal or national tribunal, the appropriate government, if satisfied that the persons applying represent the majority of each party, shall make the reference accordingly. So, my dear students, under section 10, subsection 2, where the parties to an industrial dispute apply in the prescribed manner, whether jointly or separately, for a reference of the dispute to a board, court, labor court, tribunal, national tribunal, then the appropriate government, if satisfied that the persons applying represent the majority of each party, shall make the reference accordingly. And where an industrial dispute has been referred to a board, labor court, tribunal, or a national tribunal under this section, the appropriate government may, by order, prohibit the continuance of any strike or lockout in connection with such dispute which may be in existence on the date of the reference. So under section 10, subsection 3, my dear students, where an industrial dispute has been referred to a board, labor court, or a tribunal or a national tribunal under this section, the appropriate government may by order prohibit the continuance of any strike. So no employer, no employee, no workman will go for the strike in this period, and or if there is a lockout, then lockout in connection with such dispute which may be in existence on the date of the reference would be prohibited. So no employer, no employee may go for the lockout, or in case of employee will not go for the strike. And then there's subsection 4 under section 10, there is where in an order referring an industrial dispute to a labor court, tribunal, or a national tribunal under this section, or in a subsequent order, the appropriate government has specified the points of dispute for adjudication. I beg your pardon. The labor court or the tribunal or the national tribunal, as the case may be, shall confine its adjudication to those points and matters incidental thereto. So, under this subsection, wherein an order referring an industrial dispute to a labor court, tribunal, or a national tribunal under this section, or in a subsequent order, the appropriate government has specified the points of dispute for adjudication. The labor court or the tribunal or the national tribunal, as the case may be, shall confine its adjudication to those points and matters incidental thereto. Then subsection 5 says of section 10 that where a dispute concerning an establishment or establishment has been or is to be referred to a labor court, tribunal, national tribunal under this section, and the appropriate government is of the opinion whether on an application made it in this behalf or otherwise, that the dispute is of such a nature that any other establishment, group, or class of establishments of a similar nature is likely to be interested in or affected by such dispute, the appropriate government may, at the time of making the reference or at any time thereafter, but before the submission of the award, include in that reference such establishment, group, or class of establishments, whether or not the time of such inclusion any dispute exists or is apprehended in that establishment, group, or class, or the establishments. So in this subsection 5, where a dispute concerning any establishment or establishment has been or is to be referred to a labor court, tribunal, or a national tribunal under this section, and the appropriate government is of the opinion whether on an application made it to it on behalf or otherwise, that the dispute is of such a nature that any other establishment, group, or class of establishments of a similar nature is likely to be interested in or affected by such dispute, or appropriate government may at the time of making such reference or at any time thereafter, but before the submission of the award, include in that reference such establishments, group, or class of establishments, whether or not at the time of such inclusion any dispute exists or is apprehended in that establishment, group, or class of establishments. Then subsection 6 says that where any reference has been made under subsection first A to a national tribunal, then notwithstanding anything contained in this Act, no labor court or tribunal shall have jurisdiction to adjudication upon any matter which is under adjudication before the national tribunal and accordingly. And under this subsection clause A, if the matter under adjudication before the national tribunal is pending in a proceeding before a labor court or a tribunal, the proceeding before a labor court or the tribunal, the case may be insofar as it relates to the such matter shall be deemed to have been quashed on such a reference to the national tribunal. And clause B says that it shall not be the lawful for the appropriate government to refer the matter under adjudication before the national tribunal to any labor or to any labor court or tribunal or adjudication during the pendency of proceeding in relation to such matter before the national tribunal. So it shall not be lawful for the appropriate government to refer such matter. And subsection 7 says that where any industrial dispute in relation to which the central government is not the appropriate government is referred to a national tribunal, then notwithstanding any contained in this act, any reference in section 15, 17, section 19, section 33A, 33B, and section 36A to the appropriate government in relation to such dispute shall be construed as a reference to the central government. So my dear students, you refer these sections while you are just going through this subsection 7 of section 10. And the central government, but save as aforesaid and as otherwise expressly provided in this act, any reference in any other provisions of this act to the appropriate government in relation to that dispute shall mean a reference to the state government. And subsection 8 says of section 10 that no proceedings pending before a labor court tribunal or a national tribunal in relation to an industrial dispute shall lapse merely by reason of the death of any of the parties to the dispute, being a workman, and such labor court, tribunal, or national tribunal shall complete such proceedings and submit its award to the appropriate government. So, in case means where no proceeding pending before a labor court, tribunal, or national tribunal in relation to an industrial dispute shall lapse merely by reason of the death of any of the parties to the dispute, being a workman, and such labor court, tribunal, or a national tribunal shall complete such proceedings and submit its award to the appropriate government. So this is all about the section 10, where the appropriate government is, empowered to refer the dispute to the boards, courts, or the tribunals. So my dear students, in today's lecture, you have just gone through the provisions given under Industrial Dispute Act 1947 related to the power to exempt given to the appropriate government, and section 10 where the appropriate government may make the reference of dispute to the boards and the tribunals. So thank you so much, my dear students, and I hope that this lecture will give you an insight about these sections, and please refer the Bear Act also while you are referring these PPTs or these notes. Thank you so much. Have a nice day. Bye. Take care.